Good afternoon, everyone. Welcome to this session. My name is Wei-Huan Zhao, and I'm a senior lecturer at the UNSW Law and a member of the UNSW Law's Herbert Smith Freehills China International Business and Economic Law, the CIBEL Center. And I'm delighted to welcome you all to this second session of the 2020 CIBEL Global Network Conference Series. Before I start, I would like to acknowledge the Bedigo people who are the traditional custodians of the land where UNSW Law stands. I would also like to pay my respects to the elders, both past, present, and emerging, and extend that respect to other Aboriginal and Torres Strait Islanders who are present here today. We have 4 speakers today who will be discussing some of the most current and controversial issues in international economic law and China. And if you like, the 3 pillars of international economic law: trade, investment, and finance. As we are keen to have as much interaction and engagement with all speakers, our commentators and all participants today, we will ask speakers to speak about 10 minutes to highlight the issues and their main arguments, which will be followed by a 10-minute comments from Professor Marcus Wagner. As chair, I will also share my brief comments, if appropriate, after each presentation. After Professor Wagner's comments, I will open the floor for questions. You may type in your questions using the Q&A function of Teams. You've already had the bios of our speakers and commentator. I will not read them all out again, but will only give you a brief introduction of our speakers and the topics of their presentation today. Without further ado, our first speaker is our own Professor Heng Wang, who is a professor at UNSW Law and co-director of our CIBEL Center. Heng is working on a range of important issues at the moment, with the focus on China's approach to international economic legal order, including the Belt and the Road Initiative and central bank digital currency. Heng will be talking about China and deglobalization in the post-COVID-19 world, and he'll take us through a range of challenges in international economic law today and China's role in these challenges. Heng, the floor is yours.
Thank you, Wei-Huan, and thank you everyone for joining us. It's been great to meet you all here. What I'd like to talk today is about China and the approach to international economic legal order in the post-COVID-19 world. What I'd like to see is that actually we see that there are the questions of what's a possible future approach of China in this regard. I think there are at least 2 possible paths that China may take in the COVID and post-COVID world. One path I would like to see is a possible continuation of what I call selective reshaping of international economic law. So which means that there are the rules and institutions that China is developing or reshaping in the international system. So they'll be pretty obvious in the area like the Belt and Road Initiative. So for example, we see in terms of rules, we see a large, about 200 BRI, Belt and Road documents like the MOUs, Memorandum of Understandings, and which also being implemented in the BRI projects. That also involve issues like the international standards in terms of the infrastructure projects. And also we see that they also have involved a lot of issues like the digital governance, because China also promoting the digital Silk Road. That also involves the internet governance and so on and so forth. So we see that actually this is the area where BRI is a kind of unprecedented in terms of the scope, in terms of area they cover, in terms of the soft law, the non-binding MOUs China has been concluded with subnational government like Victoria Government Australia, to other countries like Italy, New Zealand, as well as to international organizations like United Nations. And also the selective reshaping also reflects in the hard law, maybe less so. China is pushing or China's been trying to push new rules like investment facilitation. And also I would see that in terms of the institution side, China is being taking lead in broader sense within and outside BRI in area like the Asia Infrastructure Investment Bank, and China also been developing a new one, the Multinational Center for Development Finance. So you see that actually there are efforts, and also those international organizations like the AIIB will develop new rules. So you see that for the BRI, it needs rules, it needs institutions, and there are kind of effect of selective reshaping of current international rules. And also we see that's how do you understand the influencing factors. There are areas like I think there are several factors, including how do China, one is the perception and conception. In the past, we see China as being, kind of selective adaptation, China downloading the international rules. But now China is more about uploading the standards and practices to an extra regional level. So that includes not only about how do you perceive the rules, like, but also more about how China conceive new rules, because China is the leader of the BRI. And other factors include issues like the complementarity. That is how China's preference will complementary to the external rules. And there will be the area where China has a preference and want to promote. This includes investment facilitation, e-commerce, including fintech. That's also explain why China is piloting the central bank digital currency. And also the third factor is about the legitimacy, particularly international legitimacy. That includes, that's explain why China also seek the United Nations, General Assembly as a documents which refer to BRI, and also BRI documents frequently refer to the international best practice or international practices. Another pathway I would like to see is about selective engagement. That is seen, for example, in the most recent, there's a different pathway. That's seen in the January 2020, the US-China Phase 1 agreement. If you look at the Phase 1 agreement between US and China, they're quite different, contrast sharply with the TPP or CETA, the deep free trade agreements. Instead, I would call it a kind of pathway of selective engagement. It's much narrower. They focus on basically more about market access, So China committed for the first time, whatever trade agreement China signed, unprecedented amount of purchase commitments. Of course, there are also a concern about what's the implication for other countries who will have trade with China. But generally, you see that these are area where it's different from, because they focus on area only, select area, agriculture, importation, and also the purchase of services, products, and also addressing some issue like technology transfer. But you see their engagement is much narrower than usually you see even in free trade agreements. Another aspect of the selective engagement I see is that US-China has a much narrower engagement in terms of the in this issue, but they strengthen another side, the dispute settlement through largely unilateral enforcement mechanism. So the Phase 1 agreement does not have a third-party adjudication. It depends on consultation, and they may rely on unilateral measures to make sure the measure will be undertaken if there are issue with that. So you see that actually there are profound implications, I think, for the world in terms of that the rules. We still see that many rules are still vague. For example, issue about digital economy, like the data flow, or the issue like subsidies, or the internet governance, or even trade remedy issues. There are many of them remain open, as we see in the recent Australia-China trade tensions. So I think that's being in the post-COVID-19 world, what we will see is that there will be a kind of more challenges, because the WTO, if you look at broader context, WTO faces a crisis in terms of everybody. Another side, if you look at China's major economy in the world, the current pathway, either selective reshaping or selective engagement, is not more about developing stringent rules. Instead, it's more about, on one hand, soft law, BRI non-binding rules, which is on more general statement, followed by project. There are a lot of known agreements, secondary agreements, but they are not really about international treaty, about new rules. Another side, we see the US-China Phase 1 agreements, where you see have a narrow scope for many issues, but they don't really develop new rules, systematic rules on the trade issues, although they have some developments regarding trade secrets protection and so on and so forth. But these are very limited ones. They're also more limited to bilateral trade, like how do you address the agricultural sector where you face those kind of the barriers, non-tariff barrier, which is common in the agricultural sector. So we see that we are facing challenges of the lack of the sufficient of rules, particularly regarding the post-COVID-19 world, regarding market competition, regarding digital governance, regarding national security, regarding also the issues like the environment, social issues, and so on and so forth. Another issue I think we still remain a lot of pressure is about the rule inconsistency, because on one hand you have different China has taken a kind of maximized flexibility in the BRI documents, BRI instruments, but there's also another challenge. How do you have on one hand soft law, another hand the hard law to be able to fit with each other? Because all these rules, if you look at BRI, they are more bilateral, negotiated bilateral basis. So they vary according to the parties. And also that has been concluded in different contexts. Some are more general one, and some are more specific one. So you have the issue about rule inconsistency because these rules are not always being the same. And also they have the issue regarding the rule fragmentation, because we have a very slow progress in the WTO negotiation and at the regional level. If we look at China's example, there are not many new rule developments, either within the FTA or outside FTA, or within the BRI or outside. So there are an issue in that regard. And what we would like to see as a second major problem or challenge besides rule vacuum or rule inconsistency is about the possible disintegration. Because that if we look at the passes we are facing, they're likely to see less close economic integration, because selective engagement means that particularly between US and China means there are less connection regarding the value chain, and COVID-19 exacerbate such kind of challenges, and you are likely to see a more difficult situation that in the past trade is kind of stabilizer, but however, as we see in the trade war and in the COVID-19 world, more commonly you see the unilateral measure. So that is a way where, and also you have an economic slowdown, and that gives you more pressure or incentive for countries to take unilateral measures. And all these seem to see that we're moving towards the disintegration. And the final issue is that the marginalization of the multilateralism, because WTO is in a more difficult position. So I think I will finish here to see that actually China's selective engagement with the US, another side with the selective reshaping through the BRI and beyond, but we still see many challenges ahead of us. I'm happy to answer more of your questions, and I have 2 papers on selective reshaping, another one selective engagement, which can be found in full paper at researchgate.net. Thank you.
Thank you, Hen. That's very, very comprehensive already within 10 minutes. And it gives us a lot of food for thought. And I'm sure I'm going to come back to you with many good questions that our audience will actually put through. For me, I mean, I totally agree with you. I think it's a really unsettled time now, and even more unsettled because of COVID and multilateralism, plurilateralism, and even bilateralism becomes very uncertain, and we don't really know how international economic order will actually be shaped in the future, and whether we're going to see more cooperation, we're going to see more confrontation and deglobalization, as you said. I mean, it's just a question mark, big question mark there, and certainly that's the value that all stakeholders, including academics like us, we can actually contribute to, and we will definitely come back for more questions to you. Now, our second speaker is Ms. Lin Lifei from University of Hong Kong. Lifei is currently in her 3rd year PhD study in law at the University of Hong Kong, and she holds degrees from China and the UK, and she's a qualified lawyer in China, and also used to work as an attorney in Dentist Shenzhen office. And Lifei will be talking about a very topical issue today, which is about export restrictions and frankly, all of the restrictions or measures that countries have been taking during COVID as a response. And her topic is WTO reform on trading restriction measures and China's response in the context of the pandemic. Li Fei, the floor is yours.
Hello, I'm glad to here today. Today my presentation is about the WTO reform on the trade restriction measure and China's response in the context of the pandemic of COVID-19. And the research focused on the discussion of trade and trade-related issues taken to respond to the outbreak of COVID-19 under the WTO framework and how China responds to the way of the deglobalization after pandemic. Firstly, countries dealing with the economic and public health related impact of COVID-19 have adopted tremendous temporary trade or trade-related measures. Trade-related measures and more than involving around 83 countries and regions. These measures include both export and import measures. More than 64 countries or regions have placed temporary export measures. There are two main types. They are licensing or permit requirement to the export and export prohibition. Majority of temporary export measures are export restriction or prohibition of personal protection equipment, for example, masks or gloves, and certain medical products or equipment or food or other certain products. Unlike the export measures, majority countries adopt measures to promote trade liberalization on import, such as tariff reduction or exemption, temporary suspension of anti-dumping duty, exception measures, or simplification of customs clearance. Ban or restriction mentioned above on personal protection equipment and medical supplies are regarded as quantitative restriction covered directly by the Article 11 of the GATT. Article 11 of GATT disallows such measures, but the WTO does have exception clauses that allow countries to take such exceptional measures when the life and the health of their people are at stake. Essential containing three provisions of the GATT, which is Article 11 to Article 20 and Article 21. The first line of the defense for measure made in violation of Article 11.1 exception in Article 11.2. An export restriction would not be considered against the WTO rights and obligation if it is temporarily applied to prevent or to relieve critical shortage of foodstuff and other essential products. And even
so I believe there is a technical issue at Li Fei's side. So maybe I should, Li Fei, do you want to try again? We're hearing talking about Article 20 and Article 21 of the GATT as the justifications for some of the trade restrictions now. Do you want to continue from that?
okay, so can you hear me here now? Sorry.
Yes, we can hear you now, Li Fei.
Okay.
Please continue on your arguments on Article 20 and Article 21 of the GATT. Thank you.
Okay. Even if a measure is considered unjustifiable under Article 21.2a, it's possible for it to be justified under one of the general exceptions in Article 20. And also, member states can also resort to Article 21, which enable WTO members to adopt any action which consider necessary for the protection of its essential security interests. And member also must meet a serious transparency related obligation. And countries should publish promptly when taking such measures, and also required to notify when then taking such measures. And this pandemic country feels more worried about relying on China for medical resource. It can be predicted that many countries may further emphasize economic sovereignty and leading to no longer rely on China as the only product supplier. And China has to face the way of economic deglobalization in the post-pandemic era. So after the COVID-19, the outbreak of COVID-19, getting rid of China from the global supply chain, I think should include two aspects. One is the narrow sense that is only reducing the single independence of the supply chain of China and transferring some products, suppliers to other countries with related low labor costs, such as Southeast Asian country. But the huge scale effect, I think, is the key reason for the substantial reduction for the production costs, so which is make China become the global manufacturing center now. So I think it's very difficult to replace China in the short term. In the future, there may be more downstream assembly department will moving to other Asian countries, but it's supposed that they will not replace China, but form a closer regional supply chain system. That is to the global supply chain and value chain that in this restructuring, but it's still centered on China. China may strengthen the globalization by stabilizing regional cooperation. The other is the real deglobalization that is not only to reduce the dependence of the supply chain of China, but also to implement localized
Li Fei, we can't hear you again. So I'm not quite sure whether it's tech issues, and sometimes technology always fail us, and we do have the pros and cons of technology. And can you try again? All right. Okay. So maybe I just have to leave. Bear in mind the time, I maybe have to just leave you to fix the tech issues. Is that all right? Yeah, so please, I will leave you to fix the tech issues and move on to Charles, and I will definitely come back to you in the Q&A session, and I'm sure people will have a lot of questions for you about the export restrictions and trade measures that has been taken during the COVID. All right, now let's move on to our next speaker, Mr. Charles Mack from University of Glasgow. And Charles is a PhD candidate in international law at the University of Glasgow, and his research focuses on sovereign debt regulation. And Charles had degrees from Hong Kong and the UK, and he's also a fellow in a number of prestigious institutions, including the Hong Kong Institute of Arbitrators. And his topic is about China's response to the sovereign debt restructuring and a perspective from China after COVID-19. And his presentation will be talking about also some reflections on China's approach to the Belt and Road Initiative. Charles.
Thank you for your kind introduction, Dr. Zhao. Good afternoon, morning, and evening, whenever you are around the world. I'm very excited to present some of my work and progress on sovereign debt restructuring today, and which is a perspective from China after the COVID-19. And sovereign bonds are among the foremost investment products in the world, and the consequences of the financial crisis 2007 and 2009 and the subsequent sovereign debt crisis have highlighted the critical linkage between the different national economics and between sovereign debt management, financial stability, and systemic risk. The recent COVID-19 crisis has set the stage for a debt crisis and even a broader financial collapse due to the increase of financial fragility. Furthermore, China has received a wave of applications for debt relief from crisis-hit countries, including the Belt and Road Initiative, the BRI, the world's largest development program. Further, the advance of the global financial crisis 2007 and 2009 and the subsequent sovereign debt crisis have highlighted how vital an effective scheme for sovereign debt restructuring SDR can be for the international financial stability. The contemporary moment demands that a serious contemplation is given to the questions on how best SDR can be regulated and administered at the international level. The current situation at the international level is a patchwork and uneven, and numerous critiques have been raised as to the suitability of the International Investment Agreement (IIAs) as a means to resolve the SDR issues. And the market for sovereign debt is growing over time, and there were several changes in the nature of the bondholders and banks. And since the financial crisis of 2007 and 2009, there has been increasing concerns over the sovereign debt. In particular, there was a concern about whether it is appropriate to concentrate those sovereign debt in those emerging market countries, for example, Argentina and Nigeria. Moreover, awakened by the financial crisis of 2007 and 2009, central banks have underwritten a chronic growth environment to avoid accurate failures. And the recent COVID-19 crisis has set the stage for a debt crisis, and even a broader financial collapse due to the increase of financial fragility. And recently, Argentina is expecting for its 9th sovereign debt default, and the settling of debt issues for the countries is one of the crucial tasks for the government to solve its economic recession. So sovereign debt crisis will continue for the foreseeable future, and there are two shocks going to hit China's debt dynamics. Excuse me, which are pandemic stimulus and post-pandemic economic fallout. And China has received a wave of application for debt relief from the COVID-19 crisis hit countries, and potential change of the drafting of future IAAs between China and other BRI countries is required. For example, in the future, I think drafters shall anticipate COVID-19 impact by anticipating the extent to which an investment agreement may be impacted. And the recent episodes of the SDR in Greece and Argentina show that the defect of the current approach for the SDR, which is combinations of contractual approach and official interventions by the International Monetary Fund, the IMF. The size for the current sovereign lendings is outgrown the capacity of the existing international financial architecture, i.e., the current approach for the SDR to support the default case and safeguard the financial stability of the markets. And moreover, the current approach for the SDR, as I mentioned, is a patchwork and fragment. So as a result, current approach is unpredictable, disorderly, and provides insufficient relief for economic growth. So several key players is feeling the institutional victim due to the failure of establishing a coherent system to deal with the sovereign debt issues, such as the Paris Club, the London Club, and the IMF. But yet, none of them has provided bankruptcy court for those private investors to enforce debt obligations against those countries who cannot pay off its debt to initiate SDR. So the Supreme People's Court, SPC in China, has formally launched 2 branches of the International Commercial Court of China, CICC, in 2018 to adjudicate an international commercial dispute. The establishment of the CICC is driven by the desire of China to facilitate the dispute resolution related to the Belt and Road Initiative. It has been noted that the SPC take a flexible and pragmatic approach in the establishment of the CICC. Although the current legal framework for the CICC came into shape, compared with the other commercial courts in the globe, there are still ambiguities and obstacles in the operation of CICC. For example, the CICC does not have jurisdiction over case concerning investor-state dispute. However, the CPC judge states that the CICC will primarily accept the international commercial disputes that arise between equal commercial entities. And therefore, there is no bankruptcy court and code for those private investors in the Belt and Road Initiative to enforce debt obligations against those countries who cannot pay off its debt to initiate the SDR. So most of the bilateral investment treaties, or BITs, between China and countries took part in the Belt and Road Initiative are very conservative on the scope of the dispute that can submit to the international arbitration. To meet the particular needs of the sovereign debt dispute, the Chinese government shall consider establishing an international arbitration and mediation center and specific arbitration, mediation, and expert determination regime for sovereign debt-related dispute with the assistance of the United Nations Commissions on International Trade Law UNSW Working Group 3, the Investor-State Dispute Settlement Settlement Reform. However, actually, the idea for a unified SDR regime is not novel. The failed proposal for the IMF for the sovereign debt restructuring mechanism, SDRM, is one of the examples. And the IMF SDRM can be revisited and adopted for establishment of an international regime for sovereign debt dispute, and it is vital at this juncture to assess current progress towards the development of a global approach for SDR-related disputes at the international level. And the objective for the IMF SDRM is to provide a framework to facilitate the incentives between sovereign debt issuers and creditors to reach an agreement, and that is mutually beneficial to both of them in terms of its cost and efficiency. Further, the SDRM is the strongest attempt made by this international community to institute a permanent restructuring in recent years. However, the IMF SDRM has been rejected in 2003 due to the uncertainty of the desired outcome of the sovereign bonds issuers and private investors can anticipate. Although the IMF SDRM has been rejected by the member state and subject to many criticism, and actually the IMF SDRM can still be adopted as a useful framework for the effective control and regulation for SDR. More importantly, an international arbitration and mediation regime for SDR is crucial in the contemporary moments due to the high cost of the sovereign debt-related litigation. Lack of the truly independence and impartiality of the arbitrators is one of the backlash for the current investor-state arbitration system, and the establishment of an international regime and the sovereign debt dispute in China can administer a comprehensive list of sovereign debt experts acting as arbitrators or mediators. And in order to uphold the independence and impartiality of the list of the arbitrator, the Chinese authorities could take the composition of the European Court of Human Rights, i.e. elected by the Parliamentary Assembly of the Council of Europe, from the list of candidates proposed by each state as a reference. The composition of the list could be proposed by each Belt and Road member state. Furthermore, a specific set of rules and can be developed for solving dispute in the context of sovereign debt. Most importantly, the Chinese government could develop a model dispute resolution clause for sovereign bonds issues. And the Chinese government can take a World Intellectual Property Organization model ADR clause as a reference, and it can provide a set of recommendation contract clause for the submission of future dispute under a particular contract and submission agreement for the sovereign issuers. And thank you very much for your time, and thank you.
Thanks, Charles. That's a fascinating topic, and thanks for sharing so much very good information with us and arguments. It's not my area, but I feel like it's something like it needs to be based on an agreement by all the parties involved to determine what kind of rules we're gonna enforce and what will be the enforcement mechanism and so forth. So, I mean, this really brings me back to the Hans talk about, you know, the deglobalization, or if you like, the lack of agreements on what kind of rules we need, and whether the political environment now actually gives more difficulties and uncertainties on whether we're going to actually have agreement on these things. But certainly it's all related. We're going to come back to you with questions from the audience as well. Now, our last speaker today is Mr. Philip Rogers from University of California. And Philip is also a PhD candidate at the University of California and had a very impressive interdisciplinary background of economics, Chinese studies, and political science. And in addition, he also worked as a transnational corporate lawyer in Shanghai, in one of the leading Chinese law firms, Zhonglun Law Firm, Shanghai's office. Now, here we'll be talking about a very, very specific topic under China's foreign investment regime, what we know as variable interest entities, but very, very curiously from a political economy and the empirical studies perspective. So, Philip, the floor is yours.
All right, thank you, Dr. Zhou, for such a wonderful introduction. It's a great honor to be here speaking to you all this evening, this morning, this afternoon, whatever the case may be. This topic actually came to my mind when I was actually working at the law firm. One day, the partner handed me this packet from a client and said, "This client wants to learn more about this VIE thing, do some research." And it was at that moment that I read about it, and I thought hey, if I ever get the chance to write a paper about it, this would be kind of fun. Now, I might take a slightly different approach than some of the speakers have insofar as I'm going to go back in history a little bit in my presentation, perhaps get more into the forward-looking, the post-COVID world in the discussion, the Q&A. But don't worry, you haven't invaded and switched into some starting at like 1978 or something like that. We're only going to go back like 20 some odd years. And I'm going to ask the question, why has the Chinese government allowed scores of companies to use a mechanism that overtly circumvents its FDI regime for about 2 decades, primarily for the purpose of listing on foreign stock exchanges like the New York Stock Exchange, the NASDAQ, etc.? The answer that I'm going to proffer is that mixed signals and forbearance enable a minimalist reaction that enables different development agendas over time. Now, some of you in the audience might be saying, well, you know what, it happens all the time. People let laws slip. China is the land that brought us Tian Gao Hong Di Yuan, right? The skies are high and the emperor's far away. Well, what's the big deal? Well, the big deal is that the companies that use this are Sina and Tencent and Baidu and Alibaba, some of the biggest companies in China, and also some of the companies in China tied to the internet, an area where we don't exactly think of Chinese leadership as being mamby-pamby or loose or anything like that. So in the time I have, I'd like to get very quickly into one, just the mechanism itself, get into some of the jurisprudence, policy issues, etc. of it, build out a semi-theory as to how these blurred lines enable less force to advance this minimalist agenda over time, get very, very quickly into some case studies, some storytelling, as it were, about the interaction with this particular mechanism, and then wrap up. And as I said, we probably will get to the more forward-looking aspects of this in the Q&A. But on we go. So, what is a VIE? What does it stand for? It stands for variable interest entity. So the idea typically in a company that you invest in, you buy a stock, whatever, presumably you might have some voting rights, some controlling rights. A variable interest entity gets rid of that. In American parlance, it actually came about at the Enron scandal. So you can think immediately of some of the accounting gymnastics that went on there. But what happens in the Chinese case, we'll take an example, Alibaba. Alibaba is perhaps the most high profile insofar as it has used this mechanism to list an IPO that at the time was the biggest IPO in history on the New York Stock Exchange. Jack Ma goes over to the Cayman Islands to set up a holding company. That holding company then sets up a wholly foreign-owned enterprise as a subsidiary. Now, rather than being in a regulated area of the economy like the internet, that consulting company is simply a consulting company, a service company. So it doesn't have to get all the business licenses, all the sorts of things that a more regulated industry would. What that wholly foreign-owned enterprise then does is engage in a series of contracts with the actual Chinese operator, the branch of Alibaba that actually does have the business license, that actually does do all of the internet businessing and things like that. So it's like a consulting service, a consulting fee, as it were. So by virtue of that contract, that wholly foreign-owned enterprise has access to some operational profits. Those profits can then get funneled back to the holding company in a tax haven like the Cayman Islands by virtue of the subsidiary parent company relationship. And that holding company, not necessarily the Alibaba operations, but that holding company is what foreigners tend to actually invest in. So since I'm skeptical of technology, I actually went old school. I got a piece of paper. This is actually, I don't know how well this comes out on screen, but this is sort of the workaround that you see. You don't want to actually go through the government, you want to work around it, because otherwise you'd have to go through joint ventures and things of that nature, get approvals that you probably would not get, etc. And that's just a killjoy for everybody's day. all that sort of thing. So why on earth would this be allowed if it's such a direct circumvention, and why would it be a problem? Well, Article 52 of China's contract law actually talks about circumstances under which a contract can be invalidated, and one such circumstance is trying to do something illegal disguised as something legal. So this looks all nice with contracts and things of that nature, but a Chinese court could invalidate this. So this makes it somewhat risky, but it's been done for quite some time. So what exactly is going on here? Well, in drawing from political science literature, some of the contentious politics literature actually, and political economy literature and things of that nature, what I look at and see in this situation are four main things. One, forbearance. This idea of forbearance in political science has been described as something that enables electoral gains, this intentional and revocable government leniency towards certain areas of law that can actually boost electoral gains. Here in China, in the Chinese case, we tend to think of it as a business class, trying to get the business class on board with things. Two, mixed signals. So this comes from contentious politics. Contentious politics scholars of China have talked about the idea that mixed signals can actually emerge and can persist to help leaders emerge with the times. And by engaging in these mixed signals, the state can take a more adaptive approach, shall we say. Another idea is this idea of the control parable. So this too comes from one of my colleagues at UC Berkeley, who's actually got a PhD in political science, but is now at the UC Berkeley Law School. The idea that in China, oftentimes it's not necessarily clear exactly where the lines are, but there are these stories that get told about what company X, Y, or Z has done, or what journalist X, Y, or Z has done. That sort of helps kind of determine where the lines may or may not be, and we will not get into it because nobody wants to get into it on a lovely afternoon, game theory. But in a more broader theoretical sense, game theory tells us about the idea of a signaling game where strategic actors are uncertain about what kind of an actor they face. So in this particular case, a company might be uncertain about whether it's going to be a state that'll pull the rug out from under them or not. They'll say, no, you can't do this all of a sudden, but they can infer based on their beliefs about the world based on these signals that they've sent. So now to say that the Chinese state does not care would be a possible argument. That could be, but as a sort of control parable, the China Securities Regulatory Commission actually very strategically leaked a memo in 2011 to several law firms, indicating that yes, you know what, this has actually been very, very good in getting a nice positive jumpstart for the internet economy. But it's actually generally forming a distorted situation. We're not necessarily thrilled about this. Story number two, the aforementioned Alibaba. Alibaba, as many as you almost undoubtedly know, the parent company of, well, what's now Ant Financial, at the time Alipay. Alipay has to have business licenses and the like. The People's Bank of China sends a fax to Jack Ma and says, hey, are you involved in a VIE structure here? At the time, this was before Alibaba's IPO, but they were still using this sort of VIE structure to allow Yahoo and SoftBank to invest in the company. And this fact said, you know what, if you're using that VIE thing, we might not give you those business licenses. So Jack Ma, according to Yahoo at least, goes rogue, spins Ant Financial out, does some corporate shuffling and things of that nature, invalidates the contracts, all that sort of thing, so that he can get his business licenses. So speaking to the instability of it and speaking to the power that the state has to make the actors jump, that also comes into play. So now, why would you be sending these signals? Why would you allow it to happen in the first place? Political economy teaches that these are different over time. I won't bore you with the details of Alexander Gerschenkron talking about the advantages of backwardness and things of that nature and how you need a more aggressive state at certain stages of development. But the lesson still holds that at different stages you might need different things. So at the beginning, in the 2000s, when the Chinese state would really like to see a tech sector bubble up, a tech sector emerge, and things of that nature, it would be really excellent to be able to get some quick cash and things of that nature. So you might turn more of a blind eye. But over time, you start seeing leaked memos and things of that nature saying, yeah, it's not so great. And you can actually, as the state, by keeping things somewhat ambiguous, by keeping the lines somewhat blurred, send little signals here and there that says you might not want to do that. What is the advantage to that? Well, you can actually push companies away from the behavior slowly rather than just a shock force trauma. Shock force trauma might work in a domestic setting, but when you're dealing internationally with companies that have international reputations, with companies that are trying to continue to cultivate those international reputations, pulling the rug out from under them would be not so great. So you want kind of like a slowly denouement rather than a just blunt force, whack, you're done, cold turkey sort of a thing. I won't show it in the interest of keeping time, but if you actually look from between 2000 and about 2017, 2018, you actually do see a U-shaped curve, the apex being right around the 2011 period in which some of these control parables started happening. And then you see a gradual decline over time. So in the 1 minute I have left or so, I would just like to reiterate that the circumvention is actually not necessarily, I'm not arguing that this is a strategic element on the case of the Chinese government sitting back and stroking their chin and saying, aha, yes, 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 yes. But what I am arguing is that descriptively, the way the situation has played out shows that the Chinese government is not necessarily as white-knuckled as some people make it out to be. As an authoritarian government, it's not necessarily as no-nonsense, even in an area of the economy that we tend to think of it as being very no-nonsense. And in so being, it can achieve different goals at different points in time. Now, that posits a sort of post-COVID coda that I'm happy to get into more in the discussion, the Q&A, but being mindful of time, I think I shall stop here. Thank you all.
Thank you, Philip. And it's a very interesting topic and has been a long-standing topic under China's international investment regime. And as you said, that really the message will be what will happen actually after COVID-19. But the question I really have, instead of kind of comment on what I have said, the question would be either from a legal perspective or from a political science perspective. The question would be, what would happen now after the new foreign investment law, which took effect from January this year? So that will really have some impact on how the variable interest entities would actually operate and how the government would actually react to that circumventing acts in the future. And I'm happy you said that you're going to come back to these questions in the Q&A. So let me now turning to Professor Wagner. Professor Wagner is a associate professor at University of Wollongong School of Law, in which he joined in 2018 from Warwick Law School. He's one of the leading figures, obviously, in international economic law, and currently serves a number of senior positions, including as associate editor for the Journal of World Investment and Trade, and also the executive vice president for the Society of International Economic Law. We are very fortunate and appreciative to have Marcus with us today. Marcus, your 10 minutes, just give a comment on what the presenters have talked about on the range of issues. Marcus, the floor is yours.
Thanks so much, Wei Yuan. I appreciate the invitation, and good evening, good afternoon, good morning, good night, wherever you are. So my task is somewhat tricky because those are very different papers, and I'm trying to sort of put them under one heading, and your title gives me an opportunity for that. Namely, is it really deglobalization or a different type of globalization that we're going to have? We see a time in which we see a contest over rules and whose rules will lead and shape the rules of international economic governance, and therefore also international governance more broadly, not only in the economic realm. So I'm working on a project at the moment that is very much a complement to some of the presentations we've seen today under the heading of the new plurilateralism, and that explores ways to govern in the absence of an effective WTO. And all of that has, and Heng and Wei Yuan, you've mentioned this, become much more complicated in today's political environment. So let me take the papers in reverse order, if you will, because I think Philip poses a really interesting question. And I say this as someone whose field of expertise is decidedly not in corporate law and certainly not in corporate Chinese law. But I think the interdisciplinary engagement opportunity here is very welcome, and I'll leave the heavy lifting to the experts. But I think Philip is really well placed to do this because he's someone who's not from China, right? And at least from my perspective, looks at this prospect or this project from maybe a more neutral position as otherwise we would know. Why has the Chinese government allowed for companies to circumvent the FDI regime? Philip provides a very powerful or an insightful answer, and I have to say this, but with the usual set of elements, right? Data sets, case studies, game theory, and then speaking to a range of actors. That seems to come out of the sort of pocketbook of what one would expect. But maybe the insights aren't as counterintuitive as it may seem, because what I think, my speculation now, but Philip, you can respond to that. But maybe what China wants to sees greater advantages by doing is at different stages via different actors for benefits depending on the circumstance. It's very malleable, right? And we see this in different areas as well. And I'll get back to Heng's piece on that a little later. One question that I have for you then is, and I hope you can address this, is what does this mean for the relationship between private actors and the Chinese government and other actors in the field, right, internationally? Is this a relationship domestically of control, or is this the government potentially losing some control and trying to regain it? How will the new assertiveness of the Chinese government impact the VIE going forward? You sort of hint at that by giving some incendiary expressions such as the brain trust in Beijing is committed to maintaining a firm grip on society. And maybe more importantly, will the ability of the government to take away the VIE create incentives for Chinese entrepreneurs to abandon ship, right, and go elsewhere potentially after, of course, and I can't help but say that, a proper cost-benefit analysis. Because you say private actors are willing to test institutional and authoritative boundaries, not only in the West, but also in China, right? And will that potentially create some problems? And then finally, what broader lessons can we draw from the future from this research, given essentially your research, I think, stopped at 2017 or so, 2018 from the data set you provide. Is there anything that changed, not so much with the data set, but given the political circumstances we are in? Charles, my first comment was, haven't we seen this before, right? Like countries and governmental entities have relied on the private market for financing public expenditures for quite some time. We see this well before the 2009 crisis. We see the question of state insolvency being proposed in the context of the Argentinian crisis in the late 1980s and afterwards, and there's a long history of that, right? But every crisis will bring about challenges for governments, and COVID is certainly no exception. And to me, the question is, how do countries and investors, which may well be sovereigns, as we see in the case of China, right, navigate the situation? I think rightly you say the state of affairs is really messy. We don't really know where we are, and that may have an impact on the rules of IAs, but I'm not quite clear what impact that will have, and maybe you can say a little bit more about that. And then you hint at some potential responses, although I'm not sure that they're answers. And I'm not criticizing you, but the responses I don't think are necessarily the answers. Institutionally, it seems like the sort of Chinese-led idea of having a court, is that a proper forum given the power imbalances between China as the main investor for some of the Belt and Road Initiative countries, and therefore creating an institution, right? How independent do we think that is? And I have to say, I don't think that the European Court of Human Rights is a potential model in terms of the composition, because the structures are completely different. The power imbalances between China and the other countries are just vastly different. And the first thing that came to mind was he who pays the piper pays the tunes. And so I think you have to respond to that, at least in some way. Substantively, I'm not quite sure that whether the old problems would remain, namely how to shape rules that incentivize states to act prudently on the one hand, while providing fiscal autonomy at times of crisis, such as the one that we're in right now, right? And that's been the old debate. How do we navigate that particular nadir? Li Fei, I think she can hear us at this point, is the first query I always have about anyone who talks about trade and mentions the term free trade is whether we actually ever had free trade, because I'm personally fairly averse to this particular term. Maybe it's liberalized trade, but we've never seen free trade anywhere because we have regulations in most areas. I fully agree with you, by the way, that we should be going back to the WTO, and that would be a good idea. But just to play devil's advocate, why wouldn't some countries, especially the powerful ones, be better off not to do that, but rather pursue their agendas in bilateral relationships, right? To come back to Philip's area more so, in a way, the game theory would tell us that the more powerful actors would just simply shape the rules in that particular instance. And what I do like a lot is your idea of decentralization, right? It's a good term for development that I do think, however, we've seen well before COVID-19, right? This idea of being more skeptical towards China has certainly been taking place in a number of contexts that I was in for developing countries, and I think we see that coming to the fore more and more. I said a few years ago in a developed country that I won't name right now, that maybe some countries will wish the World Bank to come back, right? Because at least you get the rule of law. You may not like the rules, but you at least get the rule of law. And the question is, do we get that with China? And I mean this is a serious question. And then I can go on about Article 20B and so forth and Article 11, but I think I'll leave that to bilateral conversation we can have. I think we're finding ourselves in a time where you don't have to be Navarro to at least query whether the reliance on a single country for a number of products, not only COVID-related PPE, but also, for example, rare earths, is in the interest of other members of the international community. And I think that's the problem that we've had for quite some time. So let me leave that there and then finally turn to Heng. I have completely lost track of time way on, but I hope I have a couple more minutes left to deal with Heng's piece. We've known each other for a very long time, and so I think I've read most of your work in draft forms over the years, Heng. So I don't think you'll find you'll be surprised at what I'm going to say now. I think this distinction that you make I find really convincing, namely the selective engagement versus selective reshaping, selective engagement with the US. It's very much an a la carte picking though, right? So it's we engage and the one things that we like, not unusual in trade negotiations at all, but it's very much sort of a la carte. You can't dictate the terms in that relationship because you have a relative balance between the actors. And it's very much a turn away from the multilateralism that at least China professes to champion. And I say this exactly the way I mean it, right? That at least China professes to champion. I'm not sure that China actually does champion it as much as it says. The BRI model of selective reshaping is different from a la carte, one in which China most certainly holds the upper hand and can pretty much dictate the terms and conditions that do the reshaping. And soft law instruments that are not adjudicative in the way that one would normally think, at least as a lawyer, are a sign of that. And soft law instruments, again, I think favor the powerful more in a relationship such as the one that you've outlined. So I think, and I'll close with that, I think it's worth bearing in mind that most actors will try to use advantages they possess. China is no different from the US. China is no different from the EU in the economic field, but what we may be witnessing is a clash of governance models, and I would encourage Heng to say a little bit more about that. And like I said, I'm working on something similar called the new plurilateralism. And I don't think it's a fault of the WTO that it's not effective at the moment, because, or at least only partially, and here I'll use Heng's words, it is selective disengagement, I think, by some of the powerful actors to use the advantage they have in a game with fewer and less powerful players, and thereby potentially laying the groundwork for a new international economic governance order for the future according to their own mind or mold that they would want to have that. So one option, and not one that I think we should pursue, is that we already see in the internet space, for example, is a siloed world in which there's no longer universal access to information. If you translate that to the trade world, this would mean that we have different areas and different rules for different players. And we see that already emerging. I think BRI is a way to export not only goods, but also rules, potentially. And that's not necessarily new. If you think about IP being exported from the US at the time, if you think about the SPS arena, these are all things that are happening on a not infrequent basis. But let me just end with this. It's nevertheless really concerning, because now we have two completely different governance models that really have the potential to clash. So let me just end it there.
Thanks, Marcus. Very intriguing comments, I would say. And for those of you who have taken on board Marcus' comments and questions, I guess maybe say as a critical comments and constructive comments for your ongoing work, and that will really help you to think more about these issues and also more critically. So taking on what Marcus has ended with, I think at the end of the day, where we're going internationally in terms of international economic law, it really depends on what kind of political willingness we will have in the years to come. That will happen regionally, multilaterally, as well as bilaterally, and it pretty much will be something we will see a mix of policy making in different kind of directions. Now, let's move on to the Q&A session. We're very glad to see a wide range of interests actually in the session, because many of the questions have come through even before the event. So we selected several questions that we want to ask each of the speaker to respond briefly. In the interest of time, I would just ask each of the questions one by one, and ask in order of the presentation, and ask the speakers to respond briefly. So the first question goes to Professor Heng Wang. So the question is about, you're talking about the different possibilities in international economic law rulemaking, and what are your observations on the likelihood, what we are talking about a lot these days, about the US-China decoupling? What will be the major aspects of that decoupling if it is actually happening? And how would that actually interact with what you have mentioned about the US-China trade talks in the next phase?
So Wei Huan, I mean that I will answer here, or it's my turn to answer that? Okay.
That's right.
Yeah, thank you. And also, I think it's maybe I can also briefly answer Marcus' questions. Thank you so much for really insightful ones, and the questions I received. Appreciate that. Sorry, first one, that for the issue about the likelihood of the US-China's decoupling, I think it's been unfortunately, we see a very challenging moment, as we already see in the US-China phase one agreements. They already have a very narrow engagement. We don't really see a lot of engagement in regard of the trade in parts and components. They're more about sale, US sale agricultural products and others to China. And also we see very little engagement, or even quite challenging decoupling in terms of technology, high technology side. And that such selective engagement explains why US-China, for example, cannot really operate very well in terms of even the climate change, in terms of public health in the COVID-19 world, because the focus of the engagements are very limited and narrow one. I think it's been in terms of the implications. That means that the likely, as mentioned by Marcus, that they'll have a different standards. They have a China-led practice in the BRI and the US led practices. So that means we would like to see quite challenging time because US will push through more rigid rules, and the role of the government in government play a more important role in the international trade. So that's the US approach, and where China's approach using again that's similar in terms of strong role of the government in some extent, but also China prefer more flexibility, in the soft law approach, and they are more moving targets. So I will see that actually we'll see those kind of conflicts, And secondly, I agree that China also follow the US path, in terms of trying to reshaping or affecting world economic governance. But China's practice also make the US respond to that. As you see the free trade agreements, US try to address issue in technology and investment. So we would like to see quite challenging in terms of possible decoupling, and that affects the predictability of trading order. And that will be very challenging for businesses. Yeah, I think I'll stop here, given the time. Thank you.
Thanks, Ted. Let me take up Li Fei's presentation, and it's really a perfect opportunity for me to allow her to finish what she has left. At Li Fei, so the question we've received for you is really about your actually your proposal about the reform of the WTO and your proposal for multilateral cooperation. And the question is, what kind of results do you actually see that multilateral cooperation should or need to deliver to really as a good response to COVID-19? Li Fei. Okay, maybe Li Fei had a tech issue again. Maybe I just ask our commentator to chime in. Marcus, do you have any views on what the question I've just asked? Marcus.
Yeah, so I was going to actually comment a little bit more on Li Fei's piece on that particular issue. I'm not quite sure how the academic can actually lead to necessarily better WTO governance, because at the moment we see, to use Heng's term, or a slight variation of Heng's term, selective disengagement, right? Certainly by the US from the WTO. And I wasn't quite sure what you meant when you said it's still necessary for China to actively initiate negotiation agreements or solutions involving international epidemic prevention within the WTO. I think that doesn't quite necessarily won't happen there, but the larger question is, how do international institutions overall respond to a crisis like the one that we're seeing right now? And I think what's interesting, and I think we have Li Fei back, is that China is starting to use what I would think is very much a hegemonic approach to international institutions, namely throwing a weight around that it wasn't willing to do, or maybe wasn't able to do a few years ago. We see this in the WHO, and we started to see it in the WTO some time ago, but certainly in the current crisis, in trying to shape even the communications, apparently, in more ways than we would have imagined, I think. And well, let me just add that that's partially being made possible because of the Trump administration's almost complete disengagement from international institutions. Let's make no mistake about that. And so my response to that would be that a country like Australia, a player like the EU and other middle powers would probably be best off to band together in a much more concerted fashion, which is starting to happen a little bit if you look into certain areas. So with that, I'll finish.
All right, thanks, Marcus. Li Fei, we're glad to have you back. And would you like to give a very brief response to what Professor Marcus Wagner has just asked or commented on?
Yes, thank you. Can you hear it again?
Yes, we can hear you, please.
Thank you. I think the question. I think my answer to the Q&A and also is connecting to the part that I didn't finish. So I will give some answers. And thank you for the questions. And I think taking to the WTO's proposal on the COVID-19 related to the trade issues submitted by the countries, I think that's a hope for countries to return to the multilaterals tables on this issue, because in general, it's supposed that although the pandemic has made countries pay more attention to localization for the medical supply, but it's not all the country can achieve complete localization of supply, because it's unrealistic not only for the country with the weak manufacturing industry, but also for developed country or the emerging economy to really slowly rely on the self-sufficient to achieve their domestic public health resource supply. And even if the country localize part of their supply chain, they still need to import some of medical supplies in the event of an outbreak. And China importing medical supplies at its very early stage of the outbreak is an example. So I think the pandemic can make the country aware of the importance to reform the existing rules at the multilateral level to compensate the weakening of global supply chain as posing these special necessities. So although the country different in their specific measures or focus or concerns, I think that's a consensus on the multilateral measures to address this crisis caused by the pandemic. And therefore, I think the pandemic can also seem as a boost for countries to make them to return to the multilateral track. But I think because given have mentioned that in past in the Doha round negotiation and ongoing crisis in the dispute settlement mechanism, even if the country want to return to a multilateral table, but there's still very long and difficult journey to reach a really truly fruitful multilateral outcome. And personally, I think that's maybe to achieve different outcomes and in different stage and with different possibility and difficulty. I think maybe first we'll start by minor editing on the existing trade restriction and relevant rules like supplemental interpretation or definition of rules and greater transparency reform, and provides more target assistance on developing country or especially the LDC countries. And further is to promote the promotion, liberalization, and facilitation of the trade in goods. And the final and the most difficult one is to achieve a global comprehensive agreement relating to a set of trade measure solution for public health and global pandemic prevention and control under the WTO. So this is yes. Thank you.
Thank you, Li Fei. And that's a really good snapshot about what we need to do in the future and for how long we can get it down. No idea. International negotiation always depends on political wills. Now, the third question goes to Charles. It's a very simple question, but just ask you to elaborate on your views on how would the COVID-19 affect China's approach to the Belt and Road Initiative from the perspective of sovereign debt structuring. Charles.
Thank you. Perhaps I can address Professor Marcus Wagner's comments first. And Professor, those questions and comments are really useful and insightful, so much appreciated. And for the first questions, I think in the 2007 and 2009 crisis, I think the impact of the COVID-19, the recent COVID-19 crisis, as I supposed, has set a stage for the debt crisis. I think it's an even broader financial collapse, like a financial crisis, and the next financial crisis will be coming, and which will increase the financial fragility. And I think the post-pandemic fallout will increase the systemic risk of the Belt and Road countries, and more countries will issue sovereign debt in the foreseeable future. So therefore, the China may take a much more important role to initiate a bankruptcy court for the Belt and Road countries. And For the second question, the COVID-19 Popper Forum, the European, indeed, I think the European model is not apple to apple when comparing with the proposed China bankruptcy court for the Belt and Road Initiative. But some measures need to be taken to ensure the true independence and impartiality of the arbitrators, the adjudicators, and the judge for the court. And I think this is not an apple to apple, but it is a kind of reference that we can take to use as a reference for the arbitrators and the judges' selections. And also it seems to be a politically feasible at the current juncture to initiate a single bankruptcy court for the Belt and Road countries, since there is a lack of political will to implement it. So it's just a proposal rather than a real reform that can be taken. Thank you.
Thanks, Charles. So the last question we selected goes to Philip. So the question is really about the question I reflected on your presentation. So what's your view briefly on what would actually be the possibilities or the future in terms of the changes in China's foreign investment regime recently, and how would that actually impact on the VIEs and China's perspective on it?
Yeah, that's a great platform actually for getting into some of the wonderful comments that Marcus was so kind to give. It's still very much a legal gray area. However, when we see the new foreign investment law and we see actually measures made in the foreign investment area over time, it really is it really seems to me very clear that it's really going to go out of vogue, the VIE, to be honest with you. That combined with the politics of the situation, some of the greater scrutiny over Chinese companies, etc. But in terms of a more direct answer, you see things like cutting down the size of the restricted industries list, for example. You see things like joint ventures not necessarily having to have a 51% ownership stake from the Chinese side, etc. So very clearly trying to, in many ways, obviate it. So this, I think, will just continue. The VIE will continue to be around for the big boys, the big behemoths, the Alibabas of the world, and things like that that have been grandfathered in. But overall, the adjustments to the foreign investment law, I think, are just pushing this even more towards the way of the dinosaur in some ways. I'll stop there in the interest of time.
Thanks, Feb. Now I'm opening the floor for more questions. We're trying to deal with as many questions as we can, and you can just type in your questions in the Q&A section. Okay, so one question received now is about. So I think this is the question for all of the speakers and Marcus. The question is there a tension between some of China's recent laws that restrict the free flow of data and the emergence of China's internet companies that compete globally? And basically Google and others have built business models around the free flow of data, and I'm curious about how China's internet companies view such data localization provisions. So it kind of goes into more. I think it goes into Hans' presentation about the decoupling and also the tech competition. But it's certainly for all speakers to comment on, if you like.
Okay, so thank you, Wei Huan. I guess it's my turn to answer the question. I think this is a great question. My quick response is that actually they're absolutely very important issue because China have faced a different position. Within China, China want to data localization. That's the reason why China imposed rules on that. Another side, when Chinese businesses expand along the BRI and elsewhere, they don't really want to have a data localization. I already see one case where in Russia, where WeChat did face some challenges in short time where they cannot operate because of some formality issues. So I think along the BRI, there are not really strong push for data localization as far as I understand. So I think this issue will probably depends on where you are talking about. Within China, I think data localization will be easier, but for outside China, for China business overseas, I don't think they really want to have the data localization. And that also relates to the second phrase that negotiate between US and China. US-China may not really have a common language in this area like data flow, and that's a potential issue for world trade because you face different positions. Thank you.
Thanks, Ken. Other speakers also want to say anything about that? All right, okay, let me see. Okay, there is another question, and it's kind of related, but it's kind of broader. So the question is, with trade war between US and China ongoing, how will this affect development, adoption, and progression of emerging technologies such as cryptocurrency and blockchain during this economic recession?
Well, that's a fun question. I can try and take a whack at it. In the economic recession. So one of the big things we're trying to think about now is the siloing, as everybody knows, and things of that nature. And you think about what we're doing right now on a computer screen and things of that nature, in that medium of exchange, talking over internet connections and 5G and the whole 9 yards. So that will definitely become, in my opinion, very much more salient in terms of the global growth, the immediate engines of growth and things of that nature. Now, how do those things get invested in? Now, the sort of the angle I'm approaching this from on this panel. Are we going to see more returning home, as it were, for some of the Chinese companies through mechanisms like Chinese depository receipts that the Chinese Securities Commission has tried to push? Or are we actually going to see more integration insofar as companies trying to go global will say, well, if you we'll give you a stake so you can get off of our backs, as it were. We're not as the big bad bogeyman, as it were. You can feel free to invest through the front door, not the back, etc. So I think these issues very much are worth paying attention to and will be very central, I think, in the recovery. And that's not to downplay the manufacturing side of things. That's not to downplay the medical supply bit, but this is the sort of area of geostrategic competition.
And also, if I can add here about the question on the implication of US-China interaction about emerging blockchain and digital currency, I would see that actually we see a different approach. China basically bans the private digital currency while promoting piloting the China central bank digital currency. That will be probably the first major economy issue that, which I think central bank digital currency is like to be a game changer. And that also involves about data, that's more tricky, challenging issues. Another side we see that in the US elsewhere, they have a different ones in the past, and also US continue to permit the private digital currency, but Libra is also kind of challenging, particularly regarding the US dollar's dominant position. So you see that in the COVID-19 response, US is considering issuing also the possibility of issuing the digital dollar. So we like to see that actually the businesses industry would like to see a different approach. Again, they have different ones in China that are prohibited, in the US and elsewhere largely permitted, and they're likely to see a segmentation of the businesses in one part of the world vis-a-vis another part. So that makes the business more different than before. Thank you.
Thanks, Philip and Hen. Any other speakers want to take on the question? All right, we're actually about the time. So let me just take this opportunity and on behalf of CIBEL, thanking all our speakers from different time zones and taking the time and efforts to join us. And also, very importantly, thanking our audience and participants today for joining us. And also to remind all participants that this is the second event in the CIBEL Global Conference series, and we'll have other events coming in the next several days on investment law and corporate law and dispute resolution. So keep your eyes out for our notice, and I hope you can enjoy the subsequent series as well as you enjoy today. So thank you, good morning, good evening, and good night.